illegitimacy and discrimination based upon illegitimacy is, as I said, judged by mid-level scrutiny, and it's judged by mid-level scrutiny basically because we think it's wrong, it's unfair, it's unequal to visit the sins of the parents on the child. Illegitimacy has nothing to do with a person's ability to perform, and the court rightly suspects that if you have laws singling out illegitimates, they're probably based on some kind of prejudice. And laws based on prejudice against illegitimates, such as barring them from government benefits or prohibiting them from working in certain kinds of positions or recovering from wrongful death actions or getting certain government benefits, anything of those kinds. If you have those kinds of distinctions in treatment based upon illegitimacy, more often than not, they're not going to survive a mid-level scrutiny because the government's not going to be able to show that that kind of discrimination substantially furthers some important government objective. By the same token, the court has refused to apply strict scrutiny to discrimination against illegitimates because it recognizes that there really are some set of cases, small though they may be, but some subset of cases where discrimination against illegitimates actually makes sense. What are these subset of cases? Well, consider, for example, the area of intestate succession, where people are claiming that they are heirs to someone who died, but the person had no will. Now, in those kinds of cases, the state has rather substantial interests in the just and orderly disposition of property and the prevention of fraud. And when it has difficulty, as it does in the case of illegitimates, to see whether a person claiming to be related to the testator, actually to the intestate person, the dead person, determining whether the claimant really was related to that individual. So, because there are some small subset of cases where it is legitimate for states to treat illegitimates differently, the court applies only mid-level scrutiny, and in fact, under mid-level scrutiny, some kinds of laws that single out illegitimates will be upheld. For example, we can require illegitimates, even though we don't require others, to go through processes, if they're reasonable, to establish paternity within their lifetime or the lifetime of the person from whom they're claiming property later. But the laws have to be reasonable. They have to give a person a reasonable opportunity to establish paternity. But if you have laws like that are aimed at protecting against fraud or resolving these difficulties of proof in intestate succession, even though they make illegitimates jump through hoops that legitimates don't have to, therefore they're being discriminated against, those laws can be upheld. Okay, the final category under equal protection of the laws, where we have some form of heightened scrutiny, is in cases where the government is picking on people or burdening them because they are exercising fundamental constitutional rights. And here the story is somewhat unusual, because unlike the other cases that we've been talking about, where we have classifications and then we're treating some groups differently than others, this area of equal protection has a kinship, really, with substantive due process. And here's how it works, something like this. Let's say you have a constitutional right. For example, you have a substantive due process right to get married, or you have a First Amendment right to express yourself. Well, what if the government passes certain laws? For example, what if it says that everybody can give speeches in the park, but law professors can't give speeches in the park? Well, that's a First Amendment case, but it can also be made into an equal protection case. Or consider a law where the government said that everybody can get married, but law professors can't get married. Well, that's a substantive due process issue there, a fundamental right to marry and a burden on that right. But again, you could make this into an equal protection case. And the way you would make this into an equal protection case, and the case about speaking in the parks, is you would say, look, in both cases, individuals want to exercise fundamental constitutional rights. And the government is dividing people into groups saying some that can exercise these rights, but others can't. And that's not equal for the government to say some people can talk in the park, but law professors can't, or most people can get married, but law professors can't. And so we could frame these kinds of cases as equal protection cases. Now, if you're invoking a constitutional right, you might as well just rely on the right directly instead of framing it as an equal protection case. But here's the interesting part. The fundamental rights strain of equal protection has actually developed some rights and classified them as fundamental under the Equal Protection Clause itself. In other words, the court has discovered fundamental rights not otherwise protected by the Constitution, by specific provisions, or even by substantive due process, and now it protects them under equal protection. That's why it has this kinship with substantive due process, because we're creating fundamental rights. There are two such rights that the court has identified. One is the right of interstate travel, the so-called right to travel, and the other is the right to vote and participate in the electoral process. Now, neither of these is found in the Constitution per se. And although the right to travel, for example, could be justified under some other clauses, the court has said it has a home under the Equal Protection Clause. And the court said this in a series of cases where the court considered statutes that states had that treated newcomers, people who moved from another state, differently than long-time residents. Basically what the states were doing is they were imposing what we call durational residency requirements, making the newcomers wait, usually something like a year, for things like welfare benefits or other critically important rights like indigent medical care benefits. Well, in looking at these cases, the court said that these long durational residency requirements with respect to these basic necessities operate as a significant burden or penalty on the exercise of this fundamental right of interstate travel. And the court said, since that's the case, we're going to apply strict scrutiny, and the state didn't have a strong enough reason or a well-tailored enough law to justify these long durational residency requirements, and they were struck down. Shapiro versus Thompson, for example. Now, the court has not struck down all durational residency requirements that states have. For example, courts have upheld, and in fact you may have personal experience with this, differential tuition benefits given to persons when they move to the state. You may have to wait a year to get your in-state resident position so that you can get lower costs charged, let's say, to go to the state university in that state. It depends, the court has said, on what's at stake. How serious is the delay in getting the benefits? Will it really affect one's right to move to another state? If it does, then it's judged under equal protection by strict scrutiny. Now, the other area where the court has found a fundamental right in equal protection is the right to vote. That's not in the Constitution either, but the court has said that the right to vote is preservative of all other rights, and it is fundamental. It's very, very important. And so, the court has said, when the state imposes substantial burdens on that right, doesn't it sound like due process? It sure does, but here we are under equal protection. The court has said when the state imposes substantial burdens on the right to vote, not conventional or reasonable ones like you have to register, or you have to be a citizen, or you have to be a certain age, things of that kind. But if the state imposes substantial burdens, for example, again, long durational residency requirements like waiting for a year, or saying that you have to own property, or other substantial kinds of restrictions, then these will be struck down unless they survive strict scrutiny, and typically they do not. Now, the really interesting question under this fundamental rights strand of equal protection is how do we know what new fundamental rights count other than those already established by the Constitution? Well, there was a time, you know, when people wanted to argue that there were all sorts of fundamental rights. Fundamental rights to education, fundamental rights to housing, fundamental rights to welfare. And if there really were these fundamental rights, if the state treated you differently with respect to them, for example, if it treated the poor differently, it didn't give them enough, or it didn't provide these benefits to people who needed them really badly, then there was a notion that, oh my goodness, maybe equal protection can be used as a vehicle for imposing affirmative obligations on the government to provide at least minimum levels of these things like housing and education. But the court slammed the door on this idea in a series of cases. And it said fundamental rights under equal protection means only pre-existing, already established constitutional rights. Now, it didn't reverse itself on the right to vote or the right to travel. It just said we're going no further than that. Because the court looked around the corner and said, gee, if we go further than that, we're really setting ourselves up for second-guessing the legislature about all sorts of social and economic benefits and the minimum level of benefits that would be needed